If you are seriously injured in a rear-end motor vehicle collision, what are some steps you should take immediately after the accident if you want to pursue a personal injury claim? Rear-end accidents are very simple. Two cars are lined up with each other. The car directly behind of the car in front of them smashes into the back of the car that's in front of them. In Maryland and all over the United States, the car that does the rear ending, the car in the back, is presumed at fault. They are required to keep a safe, reasonable distance between any car in front of them, regardless of the road conditions. If the person in the front is seriously injured by a rear-end accident, there are a few things they want to immediately do to ensure they can bring a personal injury claim. Number one, call the police, ensure that the police come to the scene of the accident, get the other driver's information, and document everything in a police report. Number two, seek immediate medical treatment. Some injuries are obvious that will require going by ambulance to a hospital immediately after the accident. Others are not. If it's soft tissue related or is simply whiplash, the injured victim should still go to an urgent care type facility and then undergo the reasonable physical therapy they need. Number three, obtaining eyewitness information and getting eyewitness statements. Remember, the investigating police officer doesn't actually see how the accident happens. So the police officer's account of what happens is not admissible in court. However, eyewitnesses, persons who actually saw the accident with their own two eyes, can provide a statement of how the accident happened, and their account of what happened is admissible in a court of law. If you have any questions regarding how an injured victim can bring a serious injury motor vehicle accident in the state of Maryland, feel free to call me. I do this every single day and would love to answer any questions you may have. Thank you.
667 Law John, 667 Law John, 667 Law John, 667.